Good afternoon, everyone, and welcome to the webinar, Making It Stick, Protecting the Record for Appeal. My name is Charlie Whitman. I'm an Associate Attorney Advisor at AEquitas, the prosecutor's resource on violence against women, and I'll be moderating today's webinar. This presentation will discuss the proper creation and protection of the record during all phases of a criminal case, focusing on investigation, charging, plea agreements, trial preparation, and strategy, summation, and sentencing. It will address pretrial motions and trial briefs on anticipated trial problems and demonstrate how strategic charging decisions can result in admission of evidence that might otherwise be excluded. Before we begin the substantive portion of our program, I want to provide a brief overview of our ILINC webinar service. For the best use of ILINC, I strongly recommend using the conference line 530-881-1212, passcode 202-731-738, and that you call in from a landline. That number and passcode is also in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option, but listen with an earpiece instead if necessary. All call-in participants have been automatically muted for the duration of the webinar. You can also listen using the Internet Audio option. To connect to Internet Audio, please click the Connect button on the start screen of today's ILINC session. If you use this audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet Audio. If you have any technical issues, you can use the ILINC hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. Or you can contact ILINC directly at 1-800-799-4510. Now, I do encourage you to post comments or questions via private chat to me, Charlie Whitman, throughout today's presentation, and I will share your questions anonymously with our presenter and the group so that they can be addressed during and at the end of the webinar. Today's webinar is hosted by AEquitas, the prosecutor's resource on violence against women, through funding from the United States Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and our presenter's biography, will be emailed to you after the presentation. In addition, today's webinar is also being recorded for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conducts legal research, provide 24/7 case consultations, host specialized and state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Before we get started today, I want to ask just a few questions that you can answer using the feedback indicator on the left-hand portion of your screen. First question, there's not a right or wrong answer here, and just an informative sort of question. How many of today's participants are prosecutors? And you can use that feedback indicator on the left-hand side to choose. Just give you guys a couple of moments to answer that. So it looks like about half and half. We have 53% are prosecutors and 47% are not. And the second question we have for you all today is, how many of you have handled a criminal appeal yourself? And you can, again, use the feedback indicator to choose yes or no. Looks like about 63% of you have not handled an appeal and 38% of you have. Next question, let me just clear this for you guys. How many of you have had a case go up on appeal? You may not have handled it, but it went to appeal. You can use, once again, the feedback indicator on your left. It looks like about 57% of you have had a case go up on appeal, and about 43% have not had a case go up on appeal. So I'm just going to draw that question. Thank you guys so much for your feedback. And today's presenter is Teresa Garvey, Attorney Advisor at AEquitas. And prior to joining AEquitas, Terry worked for 22 years as an assistant prosecutor in Camden County, New Jersey. For 9 years, she was assigned to the Domestic Violence Unit, and for 5 of those years served as Deputy Section Chief of that unit. Ms. Garvey worked closely with the Victim Witness Advocacy Unit to provide education to the public and to the community leaders who come into contact with domestic violence victims. Her jury trial experience includes the prosecution of domestic violence crimes, sexual assault and other violent crimes, drug offenses, property crime, hate crime, and official misconduct. Ms. Garvey has extensive appellate experience as well and has briefed and argued numerous cases in the appellate courts of New Jersey. Terry's full biography will be emailed to you following the webinar, along with the PDF of today's presentation. I'd now like to turn the floor over to Terry for the substantive portion of today's presentation.
Good afternoon. We're going to be talking this afternoon about protecting the record on appeal, and we hope that at the conclusion of the presentation, you'll better be able to direct the investigation of a DV, sexual violence, or human trafficking case to maximize the admissible evidence at trial. You'll be able to make strategic charging decisions and prepare the judge. And I think we already went over most of this stuff. So one of the things that was very valuable to me in my career, I started my career as a prosecutor in our appellate section. And it was actually, I thought it seemed odd at first, why I'm handling appeals when I haven't even done a trial yet. But it actually was very, very valuable training for me. And what it enabled me to do is to see how an appellate court analyzes the case, how it looks at the record of the case that was tried. It allowed me to see what kinds of mistakes prosecutors or defense attorneys made that caused the court to either affirm or reverse a conviction, and gave me a lot of good ideas when it was ready for me to try a case to try to avoid some of those problems. And certainly I have not been 100% successful at that. None of us is. We're not perfect. But what we're talking today specifically is about the concept of protecting the record. And that is one of the most helpful things that you can do in your trial practice, either as a prosecutor or as an investigator from the very beginning of a case, to shore up the case so that it will be protected on appeal from being reversed. And obviously, nobody wants to get reversed on appeal. The reversal hurts the case. The case you're trying is now old during the period of time, and it could be a matter of months to 2 or 3 years before a case is resolved on appeal. In the interim, evidence gets lost. Witnesses' memories fade, whether they're lay witnesses or police officers. You lose victim and witness cooperation. Even people who are cooperative the first time around, they've moved on. They don't necessarily want to go back and do this whole exercise over again. And so people who were initially cooperative may no longer be, you may not even be able to find them anymore. The defense has already had a crack at the prosecution's witnesses. They know where their vulnerabilities are. They know what was effective on cross-examination the first time. They maybe have additional areas to explore now. And they also have the transcripts from the original trial that they can use for impeachment because, as we all know, no witness ever relates the events exactly the same way. Each time you have a prior statement or a transcript, they're getting another chance at being impeached with that prior testimony. Reversal on appeal wastes judicial and prosecutorial resources. That courtroom, that judge, that prosecutor could be handling a new case. Instead, everyone is pouring their effort into redoing something that has already been tried. And, of course, reversal on appeal hurts the victim. Victims hopefully move on after a criminal case. They've put it behind them. The case is resolved. They're healing, and now they get a call from a prosecutor or an investigator telling them, hey, the appellate court reversed the case. We have to go back to square one. And that's very discouraging. It reopens old wounds, and it certainly re-traumatizes the victim who now has to relive this whole nightmare again. And last but not least, nobody enjoys retrying a case once it's been done. On the other hand, we don't want to paint such a dark picture of being reversed on appeal that we are afraid to take on the tough cases. If all we did was ever try cases where we were certain we were going to win, where everything was locked in, we would only be taking the easy cases and not the difficult ones that often cry out for justice. It's part of our job sometimes to take that risk. And calculated risk accomplishes a number of goals besides doing justice in the individual case. It brings difficult issues to the attention of the trial and appellate courts. If your trial judge has never heard of or seen a forfeiture by wrongdoing motion, and you bring it to him or her, they may be very, very reluctant to hear that. If there's anyone who hates being reversed on appeal more than a prosecutor, it's a trial judge. They take it very personally sometimes. They view it as a reflection on them. So they are often very cautious. But you have to sometimes force them to deal with these issues. The appellate courts often aren't aware of the problems that are going on until a case comes up on appeal. They certainly can't do anything about it until an issue is presented in the course of an appeal. So that's how we make new law. That's how cases where we get all that precedent. Somebody had to try that case. Somebody had to take it up, deal with it on appeal, and have the courage to do those things so that the courts can publish these decisions, which we then can rely on, and the trial judges can rely on. These include things like refining the elements of crimes, clarifying difficult evidentiary issues, such as rape shield statutes. What kinds of evidence fits within the scope of that issue? What kinds of evidence can be admitted under Crawford or under forfeiture by wrongdoing? Reported cases, which only happen as a result of an appeal, are how we get appropriate jury charges, which are usually based on published decisions. So that's another important way that the law develops as a result of the appellate process. Having these published decisions and precedent also contributes to the ability and willingness of police officers and prosecutors to pursue quote-unquote new crimes, such as human trafficking. We all know human trafficking is a very, very old crime, probably one of the oldest. However, it's new on most people's in most people's penal codes. So, from the viewpoint of the courts, it is an unknown quantity, and from the view of law enforcement and prosecutors, same thing. Lack of precedent in case law on human trafficking was cited as a major deterrent to prosecuting a case using local human trafficking statutes. This was from a study done by the Urban Institute about identifying some of the challenges in these cases. And there was a law enforcement officer who had an opinion about why this happens, and he's talking about prosecutors, but in my view, this is very accurate. The police officer said these are not laws that a prosecutor would deal with on a regular basis in the past, historically. Most prosecutors have never touched one of these cases. There isn't a whole lot of case law on it, so it's like anything else. If you haven't done something, you aren't sure of it, and you really don't want to stick your neck out and do something you are unsure of. These are high-profile cases, and the last thing you want to do is stick your neck out and wind up getting egg on your face because you failed in your prosecution. Even though everyone fails when they do things time and again, nobody wants to fail on a grand scale, which is sometimes these cases turn out to be. And I think that's very true. These are often high-profile cases. The media is involved. They've never seen a human trafficking case. But these are cases where we have to be courageous and where we do have to stick our necks out. However, when we are taking these necessary calculated risks, when we are in good faith moving for an extension of the law beyond what the precedent would call for, it's even more critical to have a clear and a complete record to facilitate the appellate review. Good cases create better case law. And by a good case, I don't necessarily mean the ones with the strongest evidence or the most serious case, but ones where the record is complete, which enables the court to make a truly accurate decision, or as accurate as the court can make it. And, of course, the upside is that the next case will be easier. There will be precedent at that point and guidance for both the prosecutor and for the trial court. So everyone will get progressively more comfortable, more familiar with these cases, but somebody has to be first, and somebody has to be willing to step out of the comfort zone and try these cases. Now, appeals are inevitable. There is nothing that a prosecutor can do. You can try the most perfect case in the world, and that is not going to prevent the defendant from filing an appeal, and maybe a very good appeal. There are likely to be issues that are food for an appellate filing of an appeal in the very best case. No case is perfect, and no amount of care that you take can prevent that. Likewise, there are some cases where it is inevitable that there is going to be a reversal. There's been a change in the law. A witness says or does something unexpected, which we all know that they sometimes do, and different things happen. No trial goes as it's expected to. So some of that is unavoidable. But a lot of the basis for reversing of cases or remands for new trials or pleas or sentences are preventable. A lot of them are things that we can see coming, and we can at least try to head off at the pass. And among the common reasons that can be avoided includes things like failing to lay a proper foundation for the admission of evidence. You're trying to get in an excited utterance. It seems obvious that this is an excited utterance. The defense attorney doesn't object, and that may take it out of the realm of an issue on appeal, but maybe you're admitting evidence that really goes way beyond what really should be considered an excited utterance, or the judge doesn't make the proper findings, and that is a common reason. The failure of the trial court to place reasons for those rulings on the record. Maybe the judge made the right decision for the right reason, but maybe the judge did not put on the record, I'm considering this under whatever the relevant precedent is, and it's a three-part test, and under this factor I find this, under this factor I find this, and under the third factor I find that. And based upon those factors, I am making this ruling to admit or exclude this evidence. In other words, if the appellate court cannot be confident that the trial court did the right analysis, undertook the right analysis, you may be looking at a remand. The inadvertent introduction of improper prejudicial testimony is also a common problem. Sometimes, of course, witnesses do blurt out things that they should not, or a police officer may say something that is not proper. A lot of times, those incidents can be avoided by proper prepping of those witnesses and by prompt curative instructions. But that's another common pitfall on appeal. And, of course, erroneous jury charges or instructions, including the failure to give limiting instructions at the time evidence is admitted that can only be considered for a limited purpose. There's a case in New Jersey that we used to quote often or our appellate courts often quote in cases involving jury charges, and that is erroneous jury instructions are poor candidates for rehabilitation under the harmless error philosophy. In other words, no matter how strong the case is, if the court gives erroneous jury instructions, that can be the basis for a new trial in and of itself. So what do we mean when we're talking about the record on appeal? Well, usually there will be a rule under the rules, your state rules of appellate procedure, that tell you exactly what is considered part of the record on appeal. But typically, it consists of all papers that have been filed with the court, including charging documents such as the complaint and indictment or information or accusation, any motions and supporting affidavits or certifications and briefs, So any of that motion practice that you did, any paperwork that was filed in connection with that, that's all part of the record. Plea forms, forms that are filled out by counsel at the time of a guilty plea, stipulations at trial or at the time of a guilty plea, if they're in writing, those become part of the trial record. Verdict sheets that are filled out and signed by the jury foreman and handed up to the court at the time of the verdict. Pre-sentence reports, and they are in a slightly different category sometimes. They are part of the record, properly speaking. However, they may be segregated from other documents and under seal or otherwise submitted in a confidential way because they often contain personal confidential information concerning a defendant, Social Security numbers, other things about his family history or addiction, that sort of thing that normally is not made public. Sentencing memoranda that are submitted to the court by counsel at the time of sentencing, and of course the judgment of conviction that evidences the conviction. The record also includes documentary evidence that's admitted at trial. Usually documents that are marked only for identification are not part of the record. Physical evidence that's admitted, usually you would not be shipping up to an appellate court the actual gun that was admitted into evidence, but you might be submitting a photograph of the gun if it's important for the court to see something, but the gun itself is probably part of the record. Transcripts of all the motions or pretrial hearings, transcripts of the plea or the trial, transcripts of the sentencing proceedings, and any post-trial motions or anything like that, docket sheets or other documents that are kept by the clerk, orders, opinions, or other documents that are generated by the trial court. That's all part of the record. Now, one of the most important things to realize about the record is it's almost, you could almost say that it's carved in stone. The only way that the record can generally be corrected or supplemented is usually set forth in the state's rules of appellate procedure. And typically, errors or omissions can only be corrected by motion, either to the appellate court or the trial court, depending on what your court rules say, or by stipulation between the attorneys. For instance, if something was omitted in the record and both parties agree that this happened and the parties agree that by stipulation that this is part of the record, that can be typically corrected that way. And it's very, very rare, however, that you can get before an appellate court anything that was not originally part of the trial record. You must file a motion, and it's rarely permitted. So the lesson to take away from that is if you don't protect the record, it might as well never have happened, and it doesn't exist. So the first lesson is to know that when it comes to evidence, more evidence is more. First of all, it increases the chance of conviction. We don't even have to worry about the appellate decision or the appellate process unless we get a conviction. The state doesn't have the right to take an appeal. It reduces the error that having a large quantity of evidence reduces the likelihood that minor trial errors will result in a reversal. Harmless error, which I mentioned a minute ago in connection with jury instructions, harmless error is where everyone agrees or the court finds, the appellate court finds, that there was indeed an error in the trial. However, it finds that because of, typically it's the overwhelming evidence of the defendant's guilt, that there's no possible way that that error affected the jury's verdict, and therefore it's not necessary to send the case back for a new trial. So the more evidence you put in, the stronger the case is, the more likely it is that the appellate court will say, well, there was error, but, or they may say, we don't have to even decide if there was error because if there was, it was harmless. So the very first step in creating that solid, overwhelming record that we're talking about is preparation And you want to be thinking from the very beginning about how you can get in the maximum amount of evidence that is going to help support your conviction, including things like foundation. Now, during the investigative phase, before the case even comes to the prosecutor's office, and this is important for any investigators that we have with us today, the initial response by police and investigators can be critical, because often, if the evidence is not gathered and documented, and we all know this if we've been to any DB trainings, that prompt action is critical. If that evidence is not gathered and if it's not documented, often it's not available later. We can't go back and get it later. That starts with documentation of the scene. How did the scene look? How did the victim appear? What was her demeanor? What witnesses were present? What was their demeanor, especially children who were on the scene? Preserving 911 calls. Taking a formal statement from the victim and from any witnesses. Hopefully, if you can, on videotape, especially if they're important witnesses, at the very least by tape recording. Gathering all medical evidence, and that includes ambulance reports, emergency room documents, hospital treatment records. If the victim went back for follow-up treatment and there are follow-up records, getting all those together. And these statements or admissions by the defendant, including, we all know how important it is to document in police reports those spontaneous statements that can be very critical later, showing what the defendant's intent was, or showing that he knows what happened, or he knows how badly the victim was injured, or what his motive was. So very important to document those spontaneous statements as well as any admissions or interrogation that follows. Be, of course, mindful of Miranda requirements and any other requirements that your jurisdiction may have. In New Jersey, serious cases must be video recorded. They call it stem to stern recording, from the time the suspect is brought into the room until the interrogation is complete. So comply with any of those requirements. Sometimes there's a possibility of a consensual intercept before the defendant has been arrested, or there's been a right to counsel attaching. Occasionally, it's possible to have the victim or a witness call the defendant and record that conversation, and often get good admissions that way. Excuse me. Follow-up investigation, also critical. Any details, of course, that will corroborate the victim or witnesses. Any interviews with family and friends, including history of prior incidents they may be aware of between the parties. This can be important for purposes of obtaining statements, non-testimonial statements from the victim to these other witnesses that may be admissible under Crawford, under a theory such as a hearsay exception, such as excited utterances. It can also be part of a statement that can help to support a forfeiture by wrongdoing if the victim becomes uncooperative or is unavailable at the time of the trial. We want to be maintaining contact with the victims throughout this time period. We want to be offering services that will help the victim remain engaged in the process and willing to continue to cooperate. We want to be sure that we're documenting any threats or intimidation during that pretrial stage. And we all know how much defendants try to intimidate witnesses, especially victims, once they're arrested, to get them out of jail, to get them to try to drop the charges, to get them to recant their testimony. We want to be obtaining jail visitor logs when that's appropriate to see who is visiting the defendant. Is it the victim? Is it the defendant's gang member, friends, or other criminal associates? These, too, often provide evidence to support forfeiture by wrongdoing, as well as supporting possible witness tampering charges and or a consciousness of guilt jury instruction at the time of trial. You want to start to think early about whether you may need an expert in your case, either an expert on victim behavior or forensic experts, including experts such as DNA or matching wounds to weapons. You want to be thinking about whether you might, if you've got a charge for endangering the welfare of children, you may want to call an expert about the effects of domestic violence on children to support that charge. If you're trying a human trafficking case, you may want to call an expert in human trafficking to talk about, explain to the jury how traffickers operate and to explain how victims are traumatized and kept in bondage during that sometimes extended period of time. So you want to be thinking about those from the very beginning and start lining those potential experts up. You want to think about strategic charging decisions. For instance, any prior acts of domestic violence between the parties that were not the subject of criminal charges and maybe were never even reported, you may be able to charge those in the same indictment. And the advantage of that, provided, of course, that the statute of limitations has not expired, the advantage of that is, first of all, you'll be avoiding having to file a motion under 404B, which is the prior bad acts evidence rule, as to those offenses. Obviously, if those offenses are charged, then evidence concerning them is going to be admissible. In addition, if you look at your domestic violence and trafficking cases, often there is stalking involved. Stalking, of course, is a course of conduct. And therefore, any incidents that are part of that course of conduct obviously will become admissible by virtue of having that stalking charge. It's a way, again, to open up the window of evidence that can come in to support your case without having to file a separate motion. And, of course, to the extent you file additional charges, there is always the possibility of consecutive sentencing, which can result in a lengthier sentence for the defendant, more safety for the victim. If there were children present during an act of domestic violence, consider charging endangering the welfare of those children. That will enable you to bring in an expert who can explain the effect of domestic violence on the jury and thereby helping to provide the jury with yet another reason for convicting a defendant and abuser, even if the victim is resistant or actively opposing the prosecution. You should consider charging witness tampering for any acts of threats or intimidation that occur during the pretrial process, including incidents that happen at the scene all the way up until trial. And to that end, it may be desirable in some cases to seek a superseding indictment or other charging instrument to include those charges, thereby discouraging the defendant from continuing to engage in it and also giving you those additional charges that you can be dealing with during the course of your trial. And even if your state has a human trafficking statute, which I believe all but one do at this point, include those charges where it's appropriate if the conduct in your case involves trafficking. It may be that your local state laws provide more severe penalties if you charge some other statute, such as some kind of sexual assault on a child. I'm not saying forego those charges. I'm saying add the human trafficking charges if there is a basis for it. You can't have too many charges as long as your evidence will satisfy the elements of the offense. And again, you will be helping to advance the familiarity of your office, of the trial courts, and juries with this new criminal offense. Guilty pleas. If your case results in a guilty plea, that doesn't mean your job is over. It's very critical when you're taking a guilty plea to make sure that you place all the terms and conditions of the plea agreement on the record. That doesn't mean just burying it somewhere in the paperwork. It means to state at least all the important ones on the record orally at the time of the plea. You want to spell out the details of any no contact or other conditions of the plea, especially if there is a probationary sentence. You want to make sure that the defendant confirms that he understands. You also want to include the details of all penal consequences. such as the details of sex offender registration or anything else that impinges significantly on a defendant's liberty. That helps to avoid a petition for post-conviction relief at some later point based on his claim that he did not understand or it wasn't explained to him. You want to be sure that your factual basis for the guilty plea, and some of you may live in states where they still accept Alford pleas. Those were not acceptable in New Jersey. An Alford plea being, of course, one where the defendant admits his guilt without saying exactly what it was necessarily that he did. But if you are required to do that, be sure that you include in those admissions everything, all of the elements of the offense. You want to supplement the facts where necessary. If the defendant leaves out a few small details that will be important at the time of sentencing, go ahead and say to the court, we'd like to place on the record these following additional facts. If possible, get the defendant to admit to them. Say, isn't it true that? Make that part of your agreement if necessary. And getting a stipulation to some of the facts can sometimes be very effective. You can have the defendant admit to the accuracy of medical records. I once did that in a case where there was numerous very, very serious injuries, and I wanted the court to be able to look in detail at the medical records. And I just had the defendant, as a condition of his guilty plea, was that he was going to have to admit the accuracy of those records. To the extent you can get that, it does help at the time of sentencing. You want to determine early on, of course, the level of victim cooperation, and that may change over time, as we know. Sometimes a victim who is initially uncooperative will later become more cooperative as a result of support or maybe even being assaulted again. It can also, of course, as we know, go the other way. The victim may be initially cooperative and later become uncooperative. Our suggestion is that when you have a victim who may become unavailable at a later time, at the time of trial, open up what we call a forfeiture file. Just an old section of your trial notebook where you can kind of stash, as you run across them, police reports or other information that might help to support a forfeiture motion later. You also want to be keeping an eye out for non-testimonial statements that might be admissible under Crawford if your victim chooses not to participate. You want to prepare trial briefs on any problematic issues. Help to be sure that the trial court is going to be comfortable and make the right rulings on your cases, including pretrial identification procedures, which often become an issue in stranger sexual assault, any rape shield issues, the admissibility of expert testimony, including the scope of what that proposed testimony will be, the admissibility of any prior statements of the victim, including prior consistent or inconsistent statements or forfeiture, and prior bad acts, admissibility of any of those incidents. It doesn't hurt to have at least a memo and maybe a couple of cases thrown in there so that you will have them at a moment's notice if you need them. You want to prepare your witnesses properly for trial, including prepping your lay witnesses. You want to be sure that they avoid inadvertent testimony concerning inadmissible matters, such as you want to be sure that the victim doesn't allude to a period of time, oh, that's when he was back in prison on a parole violation. If it's not relevant to your case, it can create a large problem. You want to prep your experts equally, and even if your expert has testified many times in court, you want to be sure that they understand that the two of you are on the same page. You want to be sure they understand what the purpose of their testimony is and what the scope of that is. You want to be sure that they know what you're looking for from them. You want to be sure that the expert is prepared to explain her qualifications, and you want to be sure, and this is very important with victim behavior, that the expert witness avoids offering any kind of opinion on the veracity of the witness, that they're not saying whether they believed him or her or not. Pre-trial, you want to research and prepare any special jury instructions or suggested limiting instructions. This is especially important if you don't have model charges. But even if you do have model charges, make sure they fit your facts and that there isn't something that you want to change. And right before trial, you should also personally examine your physical evidence. You don't want surprises. I had a colleague once who tried a sexual assault case where the defendant testified that he had paid the victim with a bag of cocaine for sex and that it was consensual. The victim had already testified. She was off the stand. Her clothes had been admitted into evidence. And during cross-examination of the defendant, the prosecutor reached into the victim's pocket and pulled out, well, you can guess what, a bag of cocaine. You can imagine how that made the prosecution's case look. Now, had the prosecutor known about that in advance, she could have sat down with the victim, figured out how they were going to deal with this issue, and not been surprised. But having it happen in front of a jury is not the place to find out. Trial strategies include filing motions in limine. It's good to seek rulings in advance to avoid any improper reference to inadmissible matters. Sometimes the trial court will not want to rule on those kinds of issues until it has a better feel for the case, until more evidence has come in. If that happens, then ask the court to instruct defense counsel not to allude to that evidence until there's been a court ruling on its admissibility. You want to be sure that the court, when it does rule, states its analysis and its reasonings for the ruling on the record, including all the predicate factors. If the judge leaves something out, simply say, Your Honor, could you please make a ruling on such and such a factor? And usually judges are happy to do that. And if any of the rulings change what you plan to elicit from the witness, be sure you go over that with the witness before they get on the stand. If necessary, ask the judge to excuse you briefly so that you can explain it to them. You certainly don't want them to inadvertently testify that what the judge just ruled was inadmissible. Be sure to lay a proper foundation for all your evidence once the trial begins, especially testimony that's admitted as an exception to hearsay. If you are anything like me, you get very tunnel vision while you're actually trying your case. It's helpful if you can have an investigator or even court staff kind of keep an eye on the defendant's behavior, especially while the victim or any vulnerable witnesses are on the stand, to keep an eye out for any gestures on the part of the defendant or anyone in the gallery, in the audience, so to speak, who might be gesturing or trying to intimidate the witness. If that happens, of course, bring it to the court's attention immediately. If you are able to show that it was actually committed by the defendant or on the defendant's, at the defendant's request, then seek to have that admitted as evidence of consciousness of guilt, to bring out that evidence in front of the jury. Be sure that the trial court gives proper limiting instructions at the time the evidence comes in and again at the close of the case. It's important for limiting instructions to be given on the limitations on use of evidence of prior crimes, explanations to assist the jury in understanding the how they are to consider expert testimony, and doing it at the time the evidence is admitted, and again at the time of the general jury charge is the best practice. Summations offer a wealth of opportunities for shooting yourself in the foot after you've been very careful during the trial. You want to be sure that you avoid improperly vouching for your witnesses. The danger here is suggesting in some way that you believe the witness, which implies that you believe the witness because of something you know outside of what was presented before the jury. It's fine to draw inferences based on how the witness testified, but speculation about things that were not ever proven in court is not appropriate. Be careful about appeals to emotion or sympathy on the part of the jury. Often these are emotional and sympathetic cases, but you don't want to be suggesting to them that they should render their verdict based on any of those emotions. Be careful not to inject your own knowledge about domestic violence, human trafficking, or sexual assault crimes or victim behavior into your summation. If you need statistics, if you need explanations for why DV victims or sexual assault victims or trafficking victims behave in a certain way, call an expert. You can't get up and say that to the jury based on your own knowledge. That makes you the expert or you testifying. The argument must be based on the evidence presented only or on inferences drawn from that evidence. It would be proper for you to say, think about the situation this victim found herself in. Think about the fact that, and assuming you presented evidence to this effect, that her only breadwinner is in jail and she has 5 children. Are there reasons why she might not want to cooperate and keep him in jail longer? That would be proper. But for you to get up and say, we all know that DV victims do that for economic reasons would be problematic. You want to avoid prosecutorial misconduct. Of course, we all know that defense attorneys make mistakes, judges commit error, prosecutors, however, anything we do is misconduct. Some things are clearly out of line. Don't use insulting or demeaning terms when referring to the defendant in your summation or in court. You don't want to demean the defense attorney, or you may want to, but don't do it. Don't demean the defense attorney or talk about smoke and mirrors or pulling the wool over your eyes or anything along those lines is improper. Be careful. Sometimes something the defense attorney says in his or her summation will invite a response from the prosecution. As long as it's there and you don't go too far, that's usually fair game. It's better to object at the time they make that statement. But if you respond, make it clear that that's what you're doing and not just doing this on your own. Say, just as defense counsel suggested such and such, I'd suggest the opposite and respond in that fashion. Make sure your comments are based on the admissible evidence. The U.S. Supreme Court in Berger versus United States had some great things to say on prosecutorial misconduct. It's quoted quite often in court opinions. I know I have quoted it quite often in briefs that I have handled where the allegation is prosecutorial misconduct. And it's worth remembering. The prosecutor, this is from Berger versus United States, a 1935 case. The prosecutor is a representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape nor innocence suffer. And continuing in Berger, he may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. The model rules of professional conduct states under Rule 3.4e, a lawyer shall not in trial allude to any matter that the lawyer does not reasonably believe is relevant or will not be supported by admissible evidence, assert personal knowledge of facts and issue except when testifying as a witness, or state a personal opinion as to the justice of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. And you never want to win a case this way. This is a case that went up in to the Florida District Court of Appeals called Rodriguez versus State, and the prosecutor won. The opinion was a single-word per curiam opinion that stated affirmed. However, in sort of an unusual move, one of the judges on the appellate court decided not to be satisfied with that. He or she had more to say. This is Judge Ramirez. And in a concurring opinion stated, I concur that this case should be affirmed, but I write separately to express my continuing amazement at the alacrity with which prosecutors routinely and needlessly denigrate the fairness of a criminal trial. This was an open and shut case. Yet the prosecutor felt compelled on redirect to ask the victim to repeat her testimony regarding how many burglaries her business had sustained. After reiterating that she had been victimized 23 times, the prosecutor then asked how many burglaries had occurred since the defendant's arrest. After objecting, defense counsel correctly stated at sidebar, again I'm quoting from the court's opinion, correctly stated at sidebar that the prosecutor's attempted inference that the problem stopped with the defendant's arrest was, quote, one of the dumbest things he had ever heard. The prosecutor then stated he was not doing it for any particular purpose, withdrew the question, and the trial court promptly instructed the jury to disregard it. So obviously, in that case, the court found that the error, while significant, was harmless. However, nobody wants to be the subject of a concurring opinion like that. Nobody wants to win a case that way, and there's no excuse for that kind of. Well, we all have brain freezes, but that was pretty egregious. Okay, jury charges. Lesser included offenses should always be charged to the jury where the evidence even arguably supports them, and quite often even over defense objection. You should be familiar with your own state's law in that regard. In some situations, the court is compelled to give the instruction even without a defense, without the defense requesting it, or even over their objection. In other cases, not. Make sure, and it's so easy. I know I sat at the end of a long trial and just zoned out during the jury charges. Very important not to do that because stuff does get left out, stuff gets misstated. You want to be sure that the court charges the correct version of the offense when there are multiple means by which it can be committed. It's very easy for the court to accidentally charge the wrong subsection. You want to be alert and make sure that the court is reading the correct section. You want to be sure that the court issues, of course, again, any limiting charges, repeat them again at the end of the case, even if they were given at the time of the trial. You're never going to get in trouble for instructing the jury overly cautiously. Make sure that the court, if you called any experts, gets any model charges on expert testimony that are required. It's very important that the jury understands the limitations of expert testimony and its right to disregard expert testimony if it doesn't find it to be helpful. You want to also ask the court to issue any special charges that are applicable in your particular case. A couple of the charges that can be very helpful for the prosecution include flight charges or consciousness of guilt, which would include flight and also include evidence of intimidation or any threats that were made. It is important to take a look at your case law regarding consciousness of guilt. Different states have different kinds of limitations on how that charge has to be given. Typically, it will say that it's the jury's job first to find that the act was committed, the act that was committed, and then their second job is to decide whether, in fact, it was intended as consciousness of guilt or was committed for some other innocuous, innocent reason. Sentencing strategies include submitting a detailed sentencing memorandum that will detail the applicability of any aggravating factors you want the court to consider, and describing the non-applicability of any mitigating factors that you feel are even arguably going to be raised by the defense. You want to be sure that the court, it's clear when the court sentences someone that they have actually considered all those factors and either accepted or rejected them. At the time of sentencing, you also have the opportunity to provide the court with evidence that was not of record from the trial or from the plea. If you admit it in evidence at the time of sentencing, mark it as an exhibit, attach it to your sentencing memorandum, it becomes part of the record. And of course, the advantage in some of these situations is that the rules of evidence are relaxed at sentencing. So often, certain details that might be hearsay, might not have been admissible at the trial itself, are still proper considerations for the trial court at the time of sentencing. And remember that even if the trial court gives what turns out to be an appropriate sentence, if it's not clear that the court undertook the proper analysis of the necessary factors and considerations, the seriousness of the offense, any mitigating factors, any factors peculiar to that defendant, it's possible that the sentence may be reversed. And so that is very critical as well. At the time of sentencing, you should, of course, present victim impact evidence. In most states, victims have the right to present evidence at the time of sentencing. They have the right to state how the crime affected them and what they want to see happen. I would urge you to use caution with any really emotionally charged cases, such as homicide or some really tragic cases. There have been some cases, including one that happened in New Jersey, where the victim's family had prepared sort of a day in the life kind of video of a deceased victim showing how the victim had lived previously. And there was some music in the background, and they had a friend who was a professional video producer, and it was quite impressive and moving, apparently. And even though it was only the judge that heard this and not the jury, the appellate court did remand it for resentencing.
Terry, I have a participant question I'd like to just jump in and ask you. In what you were just talking about, does that mean we should include graphic pictures of a rape exam in the sentencing memo? What would you say to that question?
You certainly could do that. I think you could certainly admit evidence that would be maybe too prejudicial to present to a jury, but not too prejudicial to present to a judge. You certainly don't want to be doing it for any improper purpose. If you can articulate a legitimate reason why the court needs to see it, I think absolutely. As long as you, and you might even want to say there somewhere on the record that we realize that these are graphic and disturbing photographs. However, it's very critical. In fact, in the example that I gave where I had the defendant admit to the medical records, that was a situation where we had extremely graphic burn injuries, and we explained why it was important for the court to see them. So, yeah, I think as long as you have a good reason and articulate that, you're okay. So what we want to take away from this is to remember that it's next to impossible to supplement the record on appeal with information that wasn't part of the trial record. And if it wasn't if it wasn't presented or articulated in the record, it might as well not exist. And creating a strong, favorable record at the trial level, which begins with the very first thing that the first police officer does, will show the appellate court that the defendant received a fair trial, that the defendant was convicted on the basis of properly admitted evidence, and that the sentence imposed is fair and just and based upon proper considerations of the offense and the offender. And your hard-won conviction will be at least as secure as you can make it, at least until the petition for post-conviction relief. You will have no control over that, That's usually based on ineffective assistance of counsel, other matters that were not part of the trial proceedings. So some cases just never died. But thank you very much for your attention, everybody. And if anyone has any questions, we've got about half a minute here, I think.
Yes, and while you all just let me know if you do have any questions. I just want to thank Terry and all of you guys in attendance for your participation and dedication to increasing victim safety and offender accountability in your communities and across the country. When you exit ILINC, we encourage you to visit our website, www.equitasresource.org, where you can register for future webinars and training events and review additional information about Equitas. You're also going to be receiving a link to a survey evaluation for today's webinar, along with a copy of the PowerPoint presentation and Terry's full biography. And please respond to the follow-up email if you're interested in additional information on continuing legal education credits or other continuing education credits. And do please remember that Equitas is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, and training needs as they relate to the prosecution of violence against women. So on behalf of Equitas, thank you so much for participating in today's webinar. And Terry and I will stay on just for a few more moments if you guys have any follow-up questions. And you can also email us as well. Terry, we have one question, if you're still on the line, asking if you know of any consciousness of guilt jury instructions that could be particularly useful in creating a template. And let me know if you think that's something that we should connect with this participant directly on, and we can certainly do that as well.
I'm sorry, say that again.
Do you know of any consciousness of guilt jury instructions that could be particularly useful in creating a template?
Yeah, actually we do. There are a couple actually I think I've run across. I think I did one. I can certainly, I know I have a couple, so I can certainly forward that to the participant, after the training. I know I have it on my computer.
Great, thank you.